This morning's episode of Spinach TV, I'm sitting with Rachel Tripler from ARC Legal. Rachel, thank you for taking the time to sit with me today.
Great being here, thanks.
Rachel is an IP attorney, and the reason that I've invited Rachel to sit with me is because I see many people who are in the throes of business. They're really, really excited about what they're doing, and there's a really important piece that they could have put in place in the early stages of business that is Rachel's areas of expertise. And I want to start off, Rachel, by asking you, what is IP? What is intellectual property?
Oh, great question. So intellectual property, IP, and I'm sorry I do speak fast. It's great. This is being recorded so people can play me back more slowly. I get excited with IP. Sorry, you're probably...
It is exciting.
So IP is, I think it's the cool area of law, and it's the only reason I went into law. It's all the innovative stuff in your business. So whether it's the ideas which make your business sing and stand out from others, or whether it's something you've written, or it could just be the name of your business. You could have a very similar business to lots of other people, but maybe it's your name, your trademark that makes you stand out. So it's all those different things in your business that make your point of difference, make you stand out from others. I guess.
Nice. So it's probably an extension of that would be intangible.
Exactly. So it's the non-physical assets. And so often, and that's a really good point, they get overlooked because it's really easy to look at, okay, all the value in your business is your laptop, probably not your pens, but your phone, your equipment, your truck, your car, and things like that. People often don't think actually all of that is nothing if you don't actually own and or protect the name of your business, which is your trademark, the way it works, which could be your patents or your copyright works, or the way it looks, which makes you stand out from others. So that could be your registered designs. So it's such the intangible assets, as you say, the things you can't touch, can be the most valuable assets in your business. So, and they often get overlooked, out of sight, etc. Yeah.
And they actually are valuable, and they are assets as well, aren't they?
So much. They can be the most valuable assets in your whole business. The baseline, I know you've said, the most important things often to businesses are the trademarks and copyright when we were talking before. And if you have all these assets and then you find out you can't use the name of their business, the goodwill that you've lost if you have to rebrand and or having to change your domain name or your social media handle because someone else has the same name, just the costs of actually having to rebrand are massive, but actually losing all the following of those people who've got to know that brand, or if they've got to know somebody else using a similar brand and they have a dodgy product and therefore they don't come back to you, it's a minefield. So yeah, incredibly valuable.
Yeah. So what kind of things can you do to protect this IP?
So there are a few different things along the path of your business journey. A lot of people think about, okay, yes, I know I need to do my IP. People keep on talking about it and I'll get to it later. But actually there are lots of things you can do right at the start, and many of them are for free, which is nice. And so there's lots of things you should do right at the start, what should then be looked at again through the journey. And so what I've actually done, if I look down, because I'm trying to keep my brain together after school holidays, I've put together a one-page cheat sheet because I'm a very visual learner and I like to see everything in one place. And so there are lots of things you can do at pre-launch, startup, when you're established and trying to grow, and then even after you sell. So I know you're going to share a link to the one-page sheet afterwards, but I'll kind of talk to it to help my brain. So things you should do even before you launch are to actually check whether or not your name is being used by anybody else. I've already highlighted the fact of the cost and pain of having to rebrand. Check that no one else is using the same or similar idea in all the countries where you want to use your idea. And of course, now we're online, almost every country counts. But if you're just focusing on New Zealand, for example, focus your search here and potentially expand to Australia because we're almost an extension of that market. Also check if you've got a new product or process. You can do free Google searches, Google patent searches to check that that idea hasn't already been patented. Do a general Google image search to make sure the logo or the imagery you're using is freely licensed to use and is not infringing anybody's copyright. So make sure before you even start, do that check to make sure that you're not going to kind of be stopped before you even get going, because I don't do litigation. I've got some great litigation lawyers I send work to because I don't need that energy in my life. I'm a believer in doing the good lead work and focus on the good stuff. I mean, not saying that bad stuff won't happen, but at least do your best, kind of like parenting. So that's something you should do before you launch. Of course, you can bring in an expert to do it, but there are lots of ways you can do searches. I've got some free tools on my website you can use to do searches yourself as well. And then after you've started, just keep an eye on whether or not anybody else has started using the same or similar idea or name. Because if you let somebody else start using the same or similar idea, they might actually establish their own concurrent rights. So it's not just a once-off thing. Make sure you check kind of along your journey and save the results of those checks somewhere safe, into Dropbox or Google Drive, whatever your online system is. So make sure you track that due diligence you've done on your idea through the business. And that takes you through to when you sell. You disclose actually all those searches when your prospective purchaser comes along. If you want to sell your business, you can actually say, look, this is our market. We've been checking all the way along. No one else is in it. And it can massively increase the value of your business and brand if you can actually show, how alone you are in the market. So that's something you should do all the way along. You should also, something else you can do for free is make sure you own all your IP, and not in the sense of like, this is mine, in the sense that if you own it, then you can license it and you can sell it. Whereas if there are lots of other people with their fingers in the pie, it's much harder to see the value in that asset. So it's nice to have it within your employment contract with your employees, or third parties. If somebody's manufacturing something for you, of course, it's great to have it within that contract that you own any IP, to the extent that if they help, say, for example, I had a client come up with a beautiful way of presenting some muffins, an amazing muffin tray, and the shape was very unusual and was part of her distinctive brand recognition. People saw those and they knew it was her business before they even saw the name. So what she didn't do, so always the horror stories, what she didn't do with the manufacturer was make sure that even though the manufacturer had some input into that she owned that design, and the manufacturer couldn't then use that mold to use for other people. So it doesn't have to be a big scary contract. I mean, it's nice to have it in a contract because then it's clear. But at the very least, if you're going to a third party or with anybody, and you want to make sure it's clear who owns what, send an email afterwards and say, hey, great to meet you, just confirming I'll be giving you this design, you'll be adding some value, but I'll be owning all the rights to make that design and you won't use it for anybody else. Are you cool with that? At very least have an email. And again, that's free. So why not always make it clear? And if they go off against that email, which has both been agreed between both of you, then you've got clear rights to take them if you need to. Or it avoids that dispute because you can actually say, dude, remember our email? And most people are ethical. I mean, in my experience of more than 20 years with IP, most people are ethical, but sometimes you have to help them to be honest. You have to put them on notice by having that in writing. So yeah, keep people on the straight and narrow. So again, that's free. The other thing you should do is create a list. Like identify all the different IP in your business. So I call it an IP asset list because trying to train people to see IP as an asset, like they're hard, they're tangible objects. A list of like your trademarks, your copyright, potentially your patents and designs, and work out how important they are to your business. Like, do you care about the way you do things? In the sense, like, do you mind, maybe you're a florist, and not all you do, but the way you present flowers is the same as everybody else. So that's not your point of difference. That's not necessarily part of your IP asset list, but maybe your brand, the name under which you sell and or the imagery that you use is key to helping you stand out from others. So in your IP asset list, you would highlight your trademarks as being your most important IP and then work out what level of protection you have, which I'll come to next. So you work out the gaps in your levels of your protection and who owns it. So if a third party's designed your logo, for example, or if you're using imagery from Shutterstock or for some third party, you may not own that IP. So if it's part of your core part of branding, make sure you own it or work out a way that you can own it. And again, that IP asset list, if you go to sell in the future, is going to be gold, because you're going to be able to go to the sale and purchase agreement and say, these are all your assets. This is how we own them. This is how long we've owned them. And you'll better put a clear value on that.
Mm-hmm.
And I see sale and purchase agreements, and it just says intellectual property. And it doesn't actually define it. It just might say all trademarks or something like that. And it just slapped a number on it. So not only is it not actually recognizing how much value there is to the business, but also often the IP doesn't get assigned after people sell. And that's just, you're paying for more lawyers, and who needs that? I know I'm a lawyer. Who needs that kind of headache in their life? So make it nice and clear in that sale and purchase agreement, the ownership, and tie up those loose ends so you can actually keep all the money you make in your business. Yeah. So that's all the free stuff you can do, so no excuses if you need some homework. And so, the one page thing I did then was I broke it down into the different forms of IP, which I haven't really touched on. I think people should never be scared if they use the wrong term for the different forms of IP. Again, I've got a one-page sheet, as you know my brain by now, summarizing an overview of IP if people want to know more about them, but this is a high-level explanation. So trademarks are marks that help people stand out in trade. So hopefully that's a way of remembering it. So often it's the word. So I always use McDonald's because everybody knows it. I know it's not healthy, and hopefully people aren't watching it while listening to this while they exercise. So sorry. But if you think the word mark McDonald's, it's an obvious trademark. Yeah, I say that, and most people think of, healthy food. But then they've also got the logo, which is the golden arches. And if you see that off in the distance, even without seeing the name McDonald's, you know it's them. So that's their logo. Then you've got other more non-traditional trademarks. So you can have a three-dimensional shape be a trademark, because you see that shape and you think of one business. It's their mark and trade. So you think the shape of a Porsche. You know whose car that is even without seeing the logo on the car. So a three-dimensional shape can be a trademark, but it takes a while to show that. Same with sounds. If you hear the Greensleeve song, which I won't sing for you today, don't worry, you know it's a Mr. Whippy truck. And so that sound can be a trademark, because you hear that and you know the ice cream truck is coming and distract your children. So a sound, smells can supposedly be trademarks. There aren't very many, but if you hear smell a certain scent, then of course you know that it's a certain perfume. And supposedly touch as well, but I haven't checked lately. I haven't found any touch trademarks. But basically, anything you experience can be a trademark. So words and logos, every business will at least have a word, so a no-brainer. When you're choosing a name or logo, make sure it's distinctive. So in the sense that check the dictionary to see what the ordinary meaning of the words are. If they're words that would ordinarily be used to describe your goods or services, then you won't be able to stop anybody else using those same words. So it's, if you're going to call yourself the pen company, there's going to be lots of other pen companies out there, so you may not be able to stand out from others. Also, check Urban Dictionary. Be careful what you find, though. I've found out lots of words I didn't want to know the meaning of, because I'm obviously not very hip. But check Urban Dictionary and other dictionary and the acronym finder if your mark consists of letters, to make sure that the word hasn't become generic into something that maybe you're uncool like me and didn't pick up that it meant something. So there's always that analogy of that grandma who texted her grandson to say your grandfather died, LOL. And she thought it meant lots of love, which obviously is not the message you want to convey. So maybe you don't want to start off a funeral parlor with LOL. So yeah, do those searches to make sure it's distinctive. Also do Google Translate, make sure, obviously Google Translate is not definitive, but make sure the word doesn't mean something in a different language. And I wouldn't, use the wee TM symbol next to your brand. Lots of people think that means it's registered, which is great, but actually it's the R, sorry to draw for you, the R in a circle that means it's registered. So the TM costs nothing to add. It puts people on notice that you think it's your trademark. I call it, and I've done this example lots of times, but I call it the beware of the dog sign. So if I had a beware of the dog sign, it's true. I do have a dog. He is a chocolate Labrador, so he's more of an inappropriate sniffer than a biter. But still, it's a good deterrent. If you saw a beware of the dog, you would stop and think before you went through the gate, wouldn't you? Same with a TM. It will make people stop and think. But a TM is kind of like having a like a Labrador, a trained Labrador, not to be generic about breeds. It's like a Labrador, whereas R in a circle is like an untrained guard dog. You would not enter with an R because it's a registered trademark. Is that a good analogy? Maybe.
Yes.
It works with my brain. But yeah, put the TM on cost nothing, and it's a good stop. It's a good deterrent. I would also recommend applying to IPONs for registration. So everything else I've spoken about so far is free. Applying to IPONs is, of course, not free. IPONs is the New Zealand Intellectual Property Office, which registers trademarks and patents and designs. So in New Zealand, though, it can cost as little as $70 for each group of goods and services for 10 years registration. You'll notice I'm speaking slowly for a change because $70, I know how expensive it is starting up a business, but $70, you have no excuse. If you can't afford $70, then really, it's a no-brainer. And what a trademark registration does for you, if it's distinctive, you'll get a registration. And if it's not similar to earlier trademarks, you'll get a registration, but you've done those checks for free, so you're cool. So what it does for you is it gives you the exclusive right to use that brand throughout New Zealand in relation to the goods and services you claim in the application. So why that's important is if I was selling pens and I just filed in relation to pens, then I wouldn't have protection in relation to, say, clothing. And maybe that's also a core part of my business. Each good or service is grouped into different classes, and there are 45 classes. Each class has a fee at IPONs from $70. So that's why it's really important to work out which class is relevant to you, because once you claim pens, in that class, you've also got books and calendars and printed matter and stationery, so you can actually go really broad within that class for no extra fee. So go hard out within that class and claim all the things that are relevant that you might go into in the future. But also think laterally. Am I actually also going to go into apps and software and pens and a digital version like an e-pen? You might then want another class. So don't think just about what you're doing now. Think about where you might go in the future. And if you can afford the extra $70 per class, then do that too. Do it once, do it right. What people often also forget is class 35, which is the retail and wholesale class. And that's a great one to do because that will actually protect your name in relation to the platform from which you sell the products. If you're going to sell your pens under the same brand name, then you'll protect it in class 35. And what that does is help you stop anybody else using the same or similar domain name or company name. So with domain names, as you all know, there's so many variations of TLDs. And people often say on Facebook groups I'm in, I was trying to get this domain name and somebody else has got it. I mean, I don't care if somebody else has got the domain name I want, as long as they own the trademark and they're not using that domain name for the same services, infringing my registered trademark. I don't care, because people aren't going to guess your domain name. People don't drive around the streets and guess where you live. They look you up. So as long as your SEO is strong and you own the trademark, people are going to find you through Google search engines or other search engines, not through your domain name. I mean, it's nice to have it nice and clean and related to your brand, obviously, but you can add S's, you can add hyphens, so kind of who cares? So if you've got the trademark registration, you can stop anybody else using a similar domain name. Yes, I can stop talking.
Before you move on, I want to just pause on classes.
Yes.
So for example, spinach, I've got my brand registered and I want to stop anyone using it anywhere. Can I go and put a trademark on spinach plumbing and block out all these other potential, I just don't want anyone using spinach anywhere ever. Can I go and put random trademarks in every class?
Oh God, it's going to be a depends answers. So you can, when you file, you definitely can. So as I say, there are 45 different classes. So I know 45 times 70, again, not a massive, it's quite a lot when you start, because even $500 is quite a lot when we launch. So physically you can, but if you file and it's not, and if it's in bad faith and you've got no intention to use it for those goods or services, your registration can be revoked. And or if you don't use it for any 3-year period, then it can be revoked for non-use. And that's same with any trademark. So even when I was talking about future-proofing your brand and saying, you might go into clothing, if you then don't use it for 3 years, even though you have an intention soon, and somebody else wants to use it, they can revoke your registration for non-use. So yeah, you're right. It is something to keep in mind, but you can go crazy. The It Depends one was where it's such a well-known brand that, like Kodak, they have defensive registrations because Kodak is such an invented word. If somebody did use it for something similar, then people might think it's related. I know I saw, I can't remember. I saw a building company. I know Kevlar, a construction company. And I actually thought, what a great brand, because you kind of think of the Kevlar, the army. So I've got a son who's really into army stuff, the Kevlar body armor kind of stuff. And they've done Kevlar construction, which does make me wonder, is it related? Because, good, strong construction. And I wonder if Kevlar, how they feel about, if Kevlar Construction is here. I think it's a great brand, but I wonder how Kevlar would feel when they're kind of almost coming off their brand recognition. It's such an invented word. So I think somebody like Kevlar potentially could do those defensive registrations, because the point of icons is partly the trademark owner protection, but partly consumer protection, to make sure that different businesses are offering the same services under a same brand and causing confusion. So it depends.
Yeah, well, that's actually a really important point you made at the end there about the purpose of being tied not only to the owner of the intellectual property, but to prevent confusion to the consumer. That's a really nice little nugget there. I just want to highlight that because I think that's really important. When you're going into business, there's all sorts of things you should be aware of, and depending on whether you're a service provider or a product seller, being aware of how your customer or clients are being treated and being persuaded is really important, and acting ethically with regard to confusing people is a really important component. And trademark protection, it does bring that value too.
And I think that goes a lot to the kind of beware of the dog sign. It's helping people be ethical as well, because lots of people are confused about IP and about what they can and can't do. And it's not like, you wouldn't obviously steal somebody's, most people wouldn't. Most people wouldn't steal like a jacket they saw, sitting there kind of thing, or come past me and just take something that I've, drawn. But when things are online, people feel to be more removed, and it's like, oh, but everybody's doing it. It's like, well, everybody might go across the walking when the light's red, but actually it's illegal. You can drive through a red light if you want to, but it's illegal. You can do these things, but should you know? So I think the more you can put people on notice by doing like that TM symbol, or doing a C circle for copyright, the more you can actually show people that you're aware of your rights. It's a good deterrent, but it's also helping them stay honest. And often I say on the website and saying, hey, did you know you can use my work in this way? Actually educating people at the same time, not just being defensive. Being proactive, I think, is really important.
Yeah. And actually, that's another wee tangent that might be worth going on, because particularly people who are getting started in business, they bootstrap. And so there's a lot of DIY with regard to whether it's content, whether it's images on the t-shirt you want to get printed. And it's very simple to punch into Google some sort of content that you want to find that you can then repurpose and use.
Yeah.
But there's a big set of parameters around that as well, isn't there?
There's so much, and most of that sits around copyright. So good tangent. So we'll go into copyright. I think I'll come back to this later. So with copyright exists automatically, and often I've even had architects come to me and say, oh, can I use these plans? They haven't put the copyright symbol on it. And I'm like, well, no, just because you don't have the copyright symbol doesn't mean copyright doesn't exist. I mean, just because I don't have a beware of the dog sign doesn't mean I don't have a dog, Same with copyright. So copyright is something that just exists automatically. And so, it's good to do the copyright symbol because it puts people on notice. But if you've come up with an own original blog, or even some short blurb on Facebook or Instagram, or you've come up with your own photo, that is all your copyright work, and people cannot use it without your consent. And they can't change it without your consent, because copyright gives you the exclusive right to use, share, amend, manipulate that work. And copyright, unlike most of the other forms of IP, is an international, or effectively international right under the Berne Convention. So if somebody wanted to use if we were a Kiwi and somebody in Australia or the States or the UK or most countries wanted to use your copyright work, they're still bound to use your work in a way under their local copyright legislation, most of which is similar to New Zealand. So they still have to ask for your consent. And the other thing as well is, even if you sell your copyright or you assign it to somebody else, you'll always be the person who created that copyright. You're always the author. And so you can assert your moral rights in that work. So say you enter a big design competition and they say, okay, but we're going to own the copyright once you create it. So they'll be the economic owner that have the right to sell and license it. You can still say, that's cool, but I assert my right to be named as the author. So when they put your brand on their t-shirt and things, they have to say, by Rachel. Mm-hmm. So it's great free marketing. They still have to name you as the author. You can't assign away you being the person who created it. So that's really important. And yeah, people don't often realize that copyright exists. And that's why we put the C symbol, just to remind people. The nice thing about copyright, though, as well, I kind of mentioned that it can overlap with trademarks. So you've got the musical trademarks, but you've also got, if you've come up with a beautiful design and it's become part of your branding, you can file that as a trademark as well. And it's nice having that registered form of protection because it's got a bit more teeth and it's more tangible, I guess. It's more clear, you're right. So I would consider it trademark protection. But copyright's free, and use the C symbol. And just make sure you keep records of how you created it and how you designed it, like save them as PDFs or on your Google Drive or wherever, so you can actually show the history of when you created it in case somebody else comes along with the same design and tries to say that you copied it. If you can show that you had it first independently, then you'll have a defense. Mm-hmm. Yeah, make sure you track all that kind of thing. The thing I didn't mention about trademarks, sorry, to go back, I mentioned briefly domain names, and lots of people, when they're setting up, they register all the domain names, like they do 52 million. I think I've already said you only need one. They're one domain to rule them all, as long as you've got the trademark registration. The other thing is company names. If you need to incorporate as a company to operate, cool, talk to your accountant. I'm not a company, I'm just a Rachel. Trading is Art Legal. But Art Legal is my brand. And so actually having a company name wouldn't give me any more protection of my brand. It's the trademark registration that trumps all of them. I don't want to say trump, which is better than all of them. So don't even bother with a company name if it's not a way you need to operate. Focus on the trademark registration, because somebody could register, incorporate Arc Legal NZ Limited as a company in New Zealand, and Companies Office doesn't care. That's not their job. And somebody else could do Arc Legal South Island Limited. I mean, please don't. If they wanted to, but they couldn't actually offer my services under the brand Arc because I'm registered as a trademark. So that's just their company name. They can't use it in trade, and they can't use it as a domain name. Cool?
That's a really, really important point, because I work with people who regularly think that the registration at the Companies Office provides you with trademark protection for your brand. And so when you're registering a company, you've got to go through a couple of processes. First, you put in the name search, and then the Companies Office goes away and checks that they're happy for you to use that name. And then you're given the go-ahead, everything's fine, you can now register. And it's very important to realize that that is not brand protection. That relates to the owner of the brand. The company is not the business. So the company is the entity which owns the trading activities, and it isn't the brand. And there's a very clear distinction between those two, and that's what's so important about what Rachel's talking about. You still must proactively go and protect your IP independently from your company name registration. They're two very distinctly different things. So I just wanted to put an underscore on what Rachel was just talking about, because it's confusing. There's so much to do when you're setting up that, if you're not an expert there, you can miss stuff.
There's so much is. I mean, and Companies Office tries to do some warnings, and it does offer a one-check system, which lets you check the trademark register in Companies Office and domain names, but it doesn't let you search variations. And so I did it for an example when I was doing a speech the other day for Zeus, like Dr. Zeus. And I did a search for Zeus, and it looked like it was available to register as a trademark, and it looked like it was available as a domain name and things like that. But actually, I'd be trading off Dr. Zeus, and it would be very misleading and deceptive. So sometimes a little information is a dangerous thing, and I think it's great that IPONs and Companies Office are so easy to use. But yeah, just make sure you tread carefully, I guess. Make sure you do all the searches, and make sure you read and make informed decisions when you're doing those checks. But yeah, the company's office things drives me nuts. And I used to head the trademarks team at the intellectual property office, so I saw it even more than probably the average person. So yeah, it drives me nuts. So the company name doesn't mean squat. It's it's the legal advice. It's might be nice to have, but it doesn't matter. Yeah, cool. I've done copyright. I've done trademarks. So most people won't have registered designs or patents, but I think it's nice to know what they are because people rabbit on about them. So a registered design protects the two-dimensional pattern or ornamentation. So I've, very tidy desk. I've got my glasses case. I don't know if you can see the pattern on there. Or maybe. Yes. So the pattern on there, you could potentially register it as a design if I hadn't published it yet and if it was original. And if people saw that pattern and they knew the brand, if you think, I don't obviously have any Louis Vuitton or Gucci to show you because I'm not that person. I don't have that budget. But if you saw that kind of design on a bag and things, you'd know it was them, or maybe hopefully not a knockoff. So that can be a registered design, but it can also be copyright as an artistic work, and you could also register it as a trademark. So the reason you would register something as a design is if you can't yet get it as a trademark because it hasn't come to be recognised as a brand, you'd therefore apply for a registered design if you haven't published it yet, and that will give you the exclusive right to use that design in New Zealand for 5 years and renewable up to 15. And you can potentially file overseas in countries of interest too. And then registered designs also protect the unusual shape of something, of which I have nothing here. No, I've got nothing. I'll say the pen was really, maybe it was like a round tomato pen or something like that, which actually was really distinctive and unusual. It didn't have to be that shape to work. Then I could do it again and register design for that. So it's the non-functional aspects of a product. Mm-hmm. So a pattern or the shape. So yeah, you only get protection for registered designs in the country where you're filed. So normally you'd file in New Zealand first because it's the cheapest and the fastest to examine. And then you can file overseas in most countries within 6 months and claim protection back to your New Zealand filing date. Something I didn't mention for trademarks, sorry. So unlike registered designs with trademarks, you can have unregistered rights or registered rights. I focused on registered rights, which of course is so cheap, it's kind of a no-brainer. If you don't register your trademark, or if you find somebody else has started using a similar trademark, you may have rights under the Fair Trading Act and passing off, so unregistered trademark rights, to the extent that you can show you've got a reputation in that brand. So if you can show you've been using the brand for, say, 2 years and everybody's come to know you as the owner of that brand, then you'll better stop anybody else using the brand because otherwise people would be deceived and confused and thinking this other person was related to you. It's really costly, though, to try and improve that reputation and things like that. And if you've just launched and somebody else thinks on Facebook or Instagram, etc., and somebody thinks that's a cool brand and they file for registration, you don't have a leg to stand on. Yeah. That can't stop you continuing to use it because you started using it before them, so you can keep on using it. But they can apply to register and you can't actually stop them. So file sooner rather than later. And it's a kind of a no-brainer. Sorry to go backwards. And so patents. And don't worry, people, you use the wrong term with a lawyer or an IP attorney because, half general practice lawyers don't know the different terms anyway as well. So, patents protect an original product or process, so the way something works or an improved way of working. So patents only give protection if you've got grant in the relevant country. And in many countries, if you tell people, like with designs, if you tell people your idea before you file, you won't get it granted because it's got to be original and not published before you file. Some countries have grace periods where you can disclose it, and as long as you file within a certain amount of time, you're okay, but I wouldn't risk it. I would talk to a patent attorney, of which I'm not one, but if anybody wants a recommendation for a patent attorney, I've been doing this for so long, I know lots of great ones in different fields. I'd really recommend talking to a patent attorney if you come up with a cool idea or a way of doing something. Most of them don't charge for that initial chat. And that means if you get investors coming along later or you go to sell and they say, oh, do you have a patent? You might actually say, well, no, I talked to a patent attorney and we worked through that a patent wasn't relevant to my business. It wasn't the core value in my business. And instead, we invested the money in my brand. And that gives you so much more validity than saying, no, I didn't look at patents. They were too hard or too expensive or something that I hate. Oh, I sound like I hate lots of things. Something that drives me crazy. People say, what's the point of getting a patent? I can't afford to enforce it anyway. And my response always is, well, did you lock your car when you came here? Did you lock your house when you left? Is it going to stop people breaking in? No. Is it going to slow them down? One would hope, slightly at least. And can you then claim insurance? Yes. So it gives you that extra level of defense and protection and credibility in the business area, because most people are, again, ethical if you help them to be so. So that's patents. So yeah, I would just go through your business, spot all the IP, make sure no one else is using similar IP, make sure you own it, make sure you record it, register it if possible, and then once you've kind of captured all that IP in your business, see if you can monetize it. If you're not using, say you registered the trademark for clothing, but you're not using it and it's a really cool brand, think about selling it to somebody else, make some money to spend elsewhere in your business or license it to somebody else. And it's not a one and done thing with IP. You'll be constantly evolving and coming up with new ideas and new brands. So every time you sit down and do your business planning, or if you've got a company, you go to the board, make sure you have that IP asset list and you're constantly reviewing and saying, how can we add more value here? Or where are we losing value in those intangible assets in our business? So I guess that's Rachel's quick brain dump on IP. Hopefully it's not too much and it wasn't, it wasn't linear, sorry.
Even if, either way, we are pulling it out from the too hard basket and talking about it. And I think it's either informing people or showing them what they don't know, and then they can extend a conversation. It's been amazing. I think it's a really important takeaway to realize that your IP has value.
Yeah.
And that you need to nurture it kind of like a living, breathing thing. So you need to make sure in an ongoing way that people aren't using it, people aren't mimicking it and being deceptive with it, making sure you're not encroaching on other people, making sure that you're recording the value of it and preserving it. And as you come up with new ideas and designs and documents and whatnot, that they're protected as well. It's something that you shouldn't just set and forget. It is an asset. It's something that you have built, that you have taken time to grow and nurture, and it is part of your asset register. It's part of your value. It's part of how people feel about you, and it's don't shove it in a drawer and forget about it. And particularly with registered trademarks, they're one of those things that you're going to wish you had in place once you need to activate them.
Yeah.
As well. So, and given how cheap that Rachel said they were to implement in the first place, it's going to save you so many headaches down the road. If the examination's already taken place, the governing body has said, yes, this is an uncontested trademark at this time, you have that benchmark there for if somebody does start to approach, rather than having to prove in reverse. I've always been using it.
I've got one client now with Just Resolved. They started using the brand 20 years ago, but somebody else did where I'm down in Christchurch, and somebody started using the same brand up in Auckland at the same time, 20 years ago, in exactly the same field. And it's taken us like over a year to settle it and to work out how they can both coexist.
Wow.
And my client didn't register it and they did. So we were on the back foot, but they had extended use as well, so they had rights. But yeah, I mean, why? But yeah, your summary was perfect. It's exactly right. So it's kind of no excuses to at least do the legwork and check before you launch, I think.
Yes. Yeah, amazing. So Rachel referred a couple of times to a document. I've seen the document. It's beautiful. It's easy to read. It's succinct. So we're going to leave a link for that on Rachel's website. She's also referenced lots of free tools on her site. So make sure you go along and have a tinker and see, what's applicable for your business. And then I'm also going to leave some direct contact for Rachel as well, because you can see that she makes it really easy to understand, really approachable, and it's important that you're protecting the assets of your business, including the intangibles. So if you want to start a conversation on that topic, please go directly through to Rachel and see how it applies to your business and what you need to do to get everything in ship shape. But Rachel, thank you for taking the time to share your expertise with me. I really appreciate it.
Oh, thank you. I really enjoyed it.